in order not to waste our time. So it's my pleasure to welcome everyone, both the panelists and the participants, in this amazing webinar where the topic is on problems encountered in mediations by parties, mediators, and lawyers. And it is a part of the mediation webinar series by the Mediation Chambers and Resolve Academy, which we do every month. And we are delighted to gather such a distinguished panel for what promises to be deeply insightful discussion on topic that resonates with mediators, lawyers, and parties alike, the real-world challenges that arise during the mediation process. So we are incredibly fortunate to have Mike as now our moderator, and Annie, Ahmad, and Beverly as panelists. So Mike, the floor is yours. You can do the introduction of yourself and the panelists. Thank you very much.
Thank you, Tatwik, and thank you so much for bringing all of us together to discuss on this important topic of problems encountered in mediations by parties, mediators, and lawyers. Today, I have a wonderful panel of three, distinguished panelists who are experts in mediation, and I'm very sure that they will give their experience, they will share their insights about what they have faced and what challenges they see, and of course, how to overcome those challenges. So we have with us Annie Hambudsman. She's a senior lawyer, she's a mediator, and she's an arbitrator. She's a council member of Chamber of Mediation, Republic of Armenia. We have Amod Dalela with us. He's an arbitrator, mediator, advocate, conciliator, and of course, a founder and partner of Dalela and Dalela law firm. And we have Beverly with us. She's an arbitrator, mediator, governance, compliance, regulatory advisor. Firstly, I welcome all of you on this for this discussion, and thank you so much for taking out time today. Mediation, of course, is something which is promoted a lot. I'm very much in favor of mediation. Mediation is one of my favorite modes of dispute resolution. And just to introduce me, I'm an advocate based in Delhi. I'm a mediator and an arbitrator as well, but I'm a pro-mediation person. We are talking about mediation. And while we were in the call, we were also discussing how mediation is evolving at this point of time. So, but of course, it's a confidential process. It is seen as an effective process, but it does not come without challenges also. At one point of time, arbitration was becoming that buzzword, but now we do have, parties are opting for mediation. So when I say challenges that you faced in mediation or obstacles that you faced in mediation, I would like to take just a quick opinion from the three panelists as to what obstacles or what challenges they feel are prevalent in their respective jurisdiction. Annie, if we can start with you.
Hello everyone, I'm Annie Hambudsman, a licensed mediator, and I'm glad to have chance to introduce mediation in Armenia and challenges we faced in Armenia. And about first question, I can first of all mention the cultural differences because we are not a multinational nation here in Armenia. And different jurisdictions, different mindsets, traditions, have diverse views on conflict resolution. Maybe in some regions, mediation is widely accepted, and while in the others it's still viewed as a secondary to litigation, and this difference can result in parties entering mediation with contrasting expectations. So my advice for mediators to do some homework, to make research, to learn more about parties, more about their traditions, to know each party well, and it will help in ongoing process. Of course, enforceability of agreements and legal framework differences can also we faced in mediation, because mediator gives approval of agreement, can make some protocols or minutes, and to create an a comfortable environment of negotiation. Mediators need some basics, some knowledge of enforceability of agreements in other countries and legal framework differences in multi-typal party mediation. So there is a lack of uniformity in enforcement mechanism across borders. So what is enforceable in other in one jurisdiction might be not enforceable in another. So which often deters parties from engaging fully in mediation, particularly in cross-border disputes. So mediators must also be aware of enforceability of agreements, or maybe help parties to make decisions, or to make it enforceable. And also jurisdiction may have varying approaches to mediation, which some not having the legal infrastructure to support effective mediation. So this can complicate the process and make it less effective than parties are from different countries. And the main role of mediator in this case to create a comfortable environment for negotiation and have and reach to a stable peace between parties, because it is possible that the parties may not even present the agreement to compulsory enforcement at all. So if you can reach a really stable peace, these issues can be solved easily, I think.
Thank you so much, Annie. Thank you for giving an overview of what challenges you face in your jurisdiction. Moving on to Amod, now, what do you think are the similarities from what you've heard from Annie, or what challenges do you think are specific to India?
Mediation is not new to India. In good old days, we have seen that villages used to have this type of system, but that was totally different. At that point of time, the villagers used to bring their disputes to the village head, who used to resolve the dispute. But the difference in today's mediation and those days mediation is that the person who was sort of mediating or trying to resolve the dispute was having a different social strata. He was from a higher social pedestal. So his word was the gospel truth for the disputants. And even if the disputants were not satisfied with the decision of the person who was mediating or resolving the dispute, they used to accept it, because they were ultimately dependent on the society where they were living in. In today's mediation, the thing is, it has matured over the time, and it has been given a shape, proper shape, through the legislation, through the system, and whatever. So now what mediation we see is a voluntary process. It was not voluntary when I was referring to the previous good old days. People used to be forced to come to that person and then get their dispute resolved. But now it is voluntary. The only problem is, because it is voluntary, which is a very beautiful feature of mediation, but that becomes a shortcoming at times, because parties, when they come to mediation, they don't see it as delivering the result at the end of the day. So they are hesitant before coming to the mediation system. And that is where the mediation has to, become more popular. And when we say that it has to become popular, it means that the success stories need to be circulated among the people. And what good thing has happened is institutions like like Resolve Academy and mediation chambers and other institutions, what they are doing today, they are having the competitions in place, and the competitions are between the universities also, and non-universities also, like the institutions I just named. So this is where the people are getting, students are getting to know what mediation is, and through them the word of mouth is also spreading, and people are knowing what mediation is. Now what is required now is that the success stories, the mediation has to be successful for it to become popular, and it has to be known to people so that people have confidence in this system. And when they have confidence, then they'll come voluntarily, and then the voluntary portion of the, which is the inherent uh, part of the mediation, will be really taken care of. In India, what we have done, a very beautiful thing which Indian government, Indian court system has done. The Supreme Court has just started a 90-day period, and mediation for the nation. So mediation for the nation is a 90-day period where all the disputes pending between the parties before the Supreme Court or district courts or high courts, they are being given a chance uh, to a mediation situation, and people are being called that they can, whether if there is a element of settlement, they can go before the mediator assigned by the courts, and then they can get their dispute resolved. But what I have seen in the last 10 days is that the notices are being issued and people are not turning. So that is where the problem is. People don't see it as a successful thing, which is not true. So the responsibility lies on people like you, me, and everybody, that we have to publicize it and see that it gets its due. That's what is, I think, mediation deserves. Thank you.
Thank you so much. You've very beautifully highlighted how parties are not turning up for mediation and how we need to spread that kind of awareness about mediation and mediation as a mode of dispute resolution. Now, moving on to Beverly, I think if you can just draw as to what similarities do you see, what differences do you see?
Yeah, absolutely. I think my name is Beverly and I practice in Nigeria. I'm an attorney mediator. And it's so encouraging to see how much Nigeria shares similarities with India. So prior to the Singapore Convention on Mediation, we already had some established mediation institutes, but albeit the traction wasn't quite there. I guess I was just fortunate to fall into mediation quite by accident 7 years ago, and it's a decision I do not regret at all. But I admit I came in at a point where things were really not that popular. So one of the major we had in Nigeria was, though we had a cultural affinity, just like Ahmad said, in India, there's a cultural affinity to mediation. We practice it in the villages, with families, religiously, but there was this resistance to mediation in the corporate aspect. So lawyers in particular would say things like, oh, mediation is going to take my job. I don't think so. But luckily, we had the grounding, legislative approval in the form of the Arbitration and Mediation Act of 2023, which gave us all a sigh of relief. For the first time, mediation received some form of legislative approval. We all felt that now we can confidently talk to our clients about it. We can confidently talk to some clients, private individual clients, and say, look, this act actually backs up mediation. For the first time, you can actually have your mediations reduced into consent agreements. We also have institutions embracing mediation more and more. I can even tell you that just this week, the Supreme Court in Nigeria issued mediation rules. So every week, every month, we are seeing more and more acceptance from the institutions, because the truth is, without that acceptance and assurance, people will still be wary of mediation. So it's a great time to come into mediation. We all know the pros and cons. I don't need to go into that, but it's definitely still going to be an uphill battle. Like Ahmad said, awareness is critical. We need more education. I must thank mediation chambers. I must thank Resolve Academy for having these kind of talks where we can all gather from different countries. I see people from different countries on this platform. So it's up to us to keep spreading the word, have these competitions in the form of moods, also have these webinars, talks, papers, you name it. And then we as attorney mediators, we keep doing our best to show that mediation is not a threat to either the clients or even the lawyers. Lawyers should embrace mediation. It helps us in our work. It helps us more versatile. Those adversarial days over, we need to have a more well-rounded approach, because at the end of the day, who benefits? It's the clients that benefits. So that's where I'll leave it. Thank you.
Thank you so much. And I think hearing three of you, even though all three of you are from different jurisdictions, the challenges look very similar when we are talking about mediation. So in this session, we're not only here to understand the problems with mediation or the challenges that we are facing, we're also here to understand the root causes and, of course, explore the ways how we can strengthen mediation process for anyone who's involved in mediation. Now, when we are talking about components, this session also say challenges faced by mediators, challenges faced by parties, and challenges faced by lawyers. So these are the three important people who are involved in a mediation process. So to begin with, the challenges that parties face, I would like to put this question to Amod. What are the psychological or emotional factors that often prevent parties from engaging constructively in mediation? I think all three of you mentioned when we were talking about challenges that parties maybe are not aware of mediation or they're not willing to enter into mediation. So what are these factors? And secondly, also, how do you deal when there are power imbalances between the parties? How do you ensure that the process stays fair?
I'll take two examples of when we talk of power imbalance. One is when there is a employer-employee situation. And if there's a dispute between employer and employee, and the employee is still serving, is still in the employment of that employer, and if there's a dispute, and the mediation is done by the conciliatory machinery, which is there in India, the government machinery, there's a government official who is the conciliator. The employee, whatever you say at the end of the day, he has to accept, because he has to continue in the employment. So he will give in. It is not the settlement. It is the given by the employee. And the other example I'll give you from the construction industry, which I'm very close to. There's a dispute between the employer and the contractor, or employer or the subcontractor, and the project is in progress. During the continuance of the project, if there is a dispute and that matter gets referred to a mediator as per the terms of agreement, in the interest of continuing the project, the party which is not the employer, whether it's a contractor or a subcontractor, he would settle for whatever comes his way. He'll say, okay, in the interest of the work, let me settle. And so this is not the mediation per se. Mediation is both the parties should come to a consensus, and both should be ready to settle down for something which is genuine and justified. So the power imbalance makes this difference. This was the question raised by you, Mehak, that power imbalance, how this is going to. And the other emotional problems what have is the ego of the parties. They don't see that mediation can bring results. So first of all, they are reluctant to come to the mediation table. And if at all they come, they would just come for the sake of coming to the mediation table, pass on the time. And because it is important for them to exhaust this as a mode of dispute resolution before moving on to the other one, like arbitration or litigation, whatever it is. So they would just come here non-seriously, pass the time, and then see whatever happens. and move on to the other one because they don't take it seriously. So ego is one. Secondly, their belief in the mediation is very important. If it is not so, then it becomes the responsibility of either the mediator or the lawyers. Lawyers have a more responsibility because they are the persons who the parties would listen to at the end of the day. So these are some of the factors which are very important for parties to take mediation seriously and to repose their confidence in it. Okay, I hope I have
Yeah.
answered.
Thank you so much. Thank you so much for highlighting about power imbalances and giving the practical experiences that you've had. The examples that you've shared were, of course, of great help. And moving on, we've seen how parties, of course, face challenges. What are the challenges with parties? What are the factors that are important when we are talking about challenges by parties? Now, moving on to Annie. Annie, my question would be, we've all heard that mediator plays a facilitative role, there's an evaluative role, but of course, when you're in a real mediation, it's very difficult to balance being facilitative and evaluative, specifically when parties themselves expect advice or some form of directions. How do we deal with such instances? And secondly, what are the limitations that mediators face in dealing with parties who are negotiating in bad faith? As we've discussed, parties are either not aware of mediation or they are not willing for mediation. So if a party is sitting and negotiating in bad faith, how do you deal with it?
Thank you. So, striking the right balance between being facilitative and evaluative can really be tricky for mediators. So people like to ask for advice or are used to receiving ready-made decisions, and they want to avoid taking responsibility for making decisions. And as a mediator, first I will focus on facilitating communication by asking questions that encourage both parties to explore their needs and interests. However, then parties expect direction, especially in complex or highly legal disputes. I shift more to a more evaluative approach, because I help the parties identify options and explore alternatives without making judgments, and this empowers them to generate solutions themselves. There is no ready solutions. They must find out by themselves, but with both parties, we must search and generate solution. But sometimes in some situations, of course, I provide reality checks or suggest potential outcomes based on my experience, on their experience, and it helps to look at the situation from all sides, when they see all sides of the problem, the situation, and I help them to view the situation from every perspective they can. So it will help them to find the solution themselves. Of course, by asking questions, I check if they understood or everything is clear for them. And the most important advice I will give to mediators is the key point to make and build their opening speech very clearly and very open, and present very clearly and in detail, in a manner accessible to parties, what mediation is and who the mediator mediator is and what the role of mediation is. Then in the beginning of the process of the mediation, you speak about that. You introduce what is mediation, what is the role of mediator, and by asking questions to check if the parties really understood the explanation, when the parties truly understand who the mediator is and what their role is, we no longer expect advice or guidance from the mediator. They understand the mediator's neutrality. So all questions or expectations arise from not knowing, from not having a clear understanding to what is mediation, who is mediator, and the main advice for mediators in these situations to prevent the situations like this, to construct a clear, detailed, and understandable opening statement, and it can prevent the issues during the whole mediation process. And of course, to speak about limitation mediators face in dealing with parties who are negotiating in bad faith or using delay tactics is very important, because in many cases we can face the situation that one of parties feel uncomfortable because there is a lack of authority, or maybe he think he have a lack of authority, and as mediators we don't have authority to compel action or have sanctions for bad faith behavior party, which means that we often rely on goodwill of the parties to move the process forward. And while the mediators cannot force decisions, they can employ several strategies to manage the bad faith negotiation and delay tactics. And as a mediator, I typically address bad faith tactics by setting clear expectations up front about the need for good faith participations. If one party is delaying, I might suggest specific deadlines or actions or proposals to cope ongoing process. I can remind about the meeting a day before or contact before the meeting to check whether the party is coming or not, and be connected, in touch with parties, make reminders, follow-ups before meetings. It always will help to keep going on process. It's of course time limitations, but however, I use private sessions to address concerns privately and identify any hidden agents behind the delay tactics, and maybe we can overcome the reasons behind such behavior. And when no one is listening and intervening, maybe the party can explain the main reason of his behavior, and we can solve it in this way. So I can mention several times, and this is very important for me, that many issues, many problems can be avoided if we build clearly and good opening speech. When I must again emphasize the importance of the first meeting and opening statement, because first is essential to set clear expectations from the start, ensuring that both parties understand the need for good faith participation and stick to deadlines to make some framework of behaviors. Additionally, mediators can reframe the discussion to shift focus from impasse to shared goals, urging the parties to consider the consequences of infection, yes, and of course encourage joint problem solving when each party is involving in tools to resolve the problem. And of course, it is, of course, the main mechanism is to reality testing that helps parties to understand the real world, the impact of their positions, making them more likely to move forward. It is mean that I help them to understand and visualize the consequences of their behavior, such as referring the matter to court or arbitration, creates a sense of urgency and accountability. So it always works. I must also be mindful for power imbalances, ensuring that both parties feel heard and respected. The more powerful party might dominate the conversation or the decision-making process, which could lead to an unfair conversation, unfair environment. So I must give to all parties, the good environment, to balanced environment in which every party can speak and be heard. And if one party feels that the process is based or doesn't allow them an equal voice, they may feel resentful. I always make decision also to have another meeting with both of parties, or apart with one party and another party. So through these strategies, mediators can create an environment of openness, of accountability, and collaboration, guiding parties past delays and bad faith tactics toward a fair and mutually beneficial resolution, with fair environment, fair negotiation, and connection with each other. I mentioned most useful methods when can help really mediators to solve the problems, these problems during mediation.
Thank you so much, Annie. Thank you so much for highlighting how do you balance the facilitative and evaluative role, and of course, especially the strategies that have worked for you, like reality testing, like separate sessions with the parties, highlighting the positions and interests, doing a very strong opening. So I'm very sure that with the strategies that you've mentioned, or the challenges that are being faced by mediators per se can be reduced to some extent. Now, we've talked about parties, we've talked about mediators. Next, we need to talk about lawyers. Of course, a lot of times we've seen that lawyers do not promote mediation as a mode of dispute resolution. There are various reasons to it, but yes, my next question would be to Beverly. And according to you, do you think sometimes lawyers get into over lawyering, and how this can be avoided? And what exactly should the role of lawyers be when we are talking about mediation per se? Whether they could be active strategists, whether they have to be silent observers, or whether they have to be collaborative problem solvers.
Thank you, Mahak. You've given me quite a lot to go with. So I think the first thing I would say is there's a lack of understanding from lawyers. And when I say lawyers, I mean those who are mostly litigators. So they tend to have a very narrow view of what their role can be in mediation. So as a result of that narrow, I would say, ignorance, maybe it's no fault of theirs, they tend to do the over-lawyering, as you call it. I've been fortunate to act in many capacities not just as a mediator, but also as an advocate, accompanying a client to a mediation. And a lot of the time, I do see that lawyers tend to disrupt these sessions. I think they feel that they are acting in good faith. I know Annie talked a lot at length about good faith and coming into negotiations with sincerity or not. I feel that lawyers believe that it is their role in a mediation to defend the rights of clients. And as a result, they have these obstructive kind of behaviors, which of course is completely counterproductive. So I think the first thing I would say is, again, it all comes back to awareness and training. Many lawyers also believe that they are natural mediators. Again, I would challenge that assertion. There is no such thing as a natural mediator, no matter how pleasant and how conciliatory you may be by nature. We've all, my co-panelists, yourself, the members of mediation chambers, we've all had to go through certain levels of training because there's certain biases that we carry as counsel. Let's be very honest. So for me, it's a call to raising the awareness about training and the opportunities that lie for lawyers in mediation. There's a lot of opportunity, and I'll take us through that one by one. So when you look at a mediation, you unpack it. You've got the pre-mediation phase, you've got the phase during the mediation, and then you've got the post-mediation, hopefully resulting in a settlement. For the pre-mediation phase, there's a lot a lawyer or counsel can do in that phase. They can act as a guide. You know, we're all talking about the fact that mediation is still coming up. It's still gaining traction. It's still nowhere where litigation is, and it's still not quite on par with arbitration yet. But I do believe that we will soon be on par with arbitration. So there's a lot that counsel can do to raise awareness with their clients about the processes involved in the mediation. Our clients may be none the wiser. It might be their first mediation experience. They'll have no idea what to expect. So it is for counsel who's well-versed in mediation to explain the do's and don'ts, the processes, what's involved, and that the mediator themselves is not a judge or an arbiter. They are merely there to facilitate conversation. So actually, it's an opportunity for counsel to extol the virtues of mediation, in that mediation can empower you as a client. I think Annie talked a lot about how to best present the needs and wants of both sides. So clients are empowered, but the lawyers have to make their clients see that. I think lawyers have a tendency, correct me if I'm wrong, to want to sort of have this very protective role, and they want to speak on behalf of the client, and there's a place for that. But it's important that counsel tell their clients that mediation is an empowering process, and we can use mediation in a strategic way. So counsel can of course explain how it works. Counsel can strategize with their clients. Okay, you're going to present the facts. You're not going to go into certain details on the emotional sides. This is a win-win. We're not going in. It's not an all-out winning situation. Counsel will do best to give the realities of mediation rather than going into it with a sort of gung-ho, we have to win and we have to put our case forward approach. So that's the pre-mediation side. And also, of course, counsel can help best present the facts. Mediation is about, compromise. You meet me in the middle, I meet you in the middle. So counsel will work with their client to best present a compromise and a sort of a negotiated settlement. How best can we get what we want by also recognizing what the other side wants? Then by the time the mediation actually kicks off, the counsel can just be there as a guide. They may take more of a backseat role this time, allowing conversation to take place. Of course, counsel can still play a protective role in the sense that if they notice anything untoward or strange, they can certainly raise it with maybe the mediator during the caucus. So for those of us who don't know what a caucus is, during a mediation, when things get a little tense, a mediator can say, I'm going to break this joint session into 2 or 3, depending on how many people, how many parties there are, and have private engagements with each party. It's really during the caucus that a council might be able to present some inside or background information that perhaps they don't want to present in the public forum. So counsel can certainly play a facilitative role to help move that mediation forward. Then when we want to talk about what happens during, say, the post-settlement process, counsel too can review the settlement agreement. I mean, I had one recently, and the counsel on the other side were very insistent about checking the agreement. There were some things that they didn't like. So again, it was almost like we had to, again, make sure that the terms were fine with all parties. So the lawyers have this sort of, they play it's the devil in the detail. The lawyers check all the details, but they don't do it in a aggressive manner. Because if you're in the session and the lawyer is constantly badgering, no, I don't like that, you go nowhere. So the lawyer has to realize that there is a sensitivity that comes with mediation sessions. There's an emotional intelligence that lawyers need to deploy, especially in mediation. And that definitely comes to the fore and helps move mediations along. I can tell you, when the difference between lawyers who do the lawyering thing and the lawyers who understand the nuances of mediation, those mediations tend to move a lot faster. So lawyers can really be very strategic. They can move from active when the time calls for it, to more passive, to more of a counselor guidance role. So lawyers do have a role, and I do welcome more and more lawyers embracing both roles, acting as attorney mediators. We're very fortunate in Nigeria to have a very active attorney mediation association. It started back in 2019, just before the COVID, and it's gained a lot of traction. Lawyers need their own specialist training, so we need to kind of in a gentle manner, not put them down or be condescending, but make them realize that it's a double arsenal. You can be a lawyer when the time calls for it, and you can also actually act as a mediator, or you can be a lawyer that is sensitive to the nuances of mediation. So there's a whole lot that lawyers can do to facilitate the process and to be part of the process in a positive way that helps both sides actually reach a resolution. So honestly, I think lawyers need to embrace. I think maybe we need to see mediation training for lawyers. I'm yet to see that, but I think it's something that maybe mediation chambers and Resolve Academy might want to think about. It's something worth looking into. So that's my 2 cents for now.
Thank you so much, Beverly, and thank you for highlighting that even though mediation is a party-centric process, but lawyers do play an important role. And your suggestion about mediation training for lawyers is fantastic. I think lawyers also need to be trained about what their role is in mediation and how to go about mediation. Yes, there are some questions that we will ask all the panelists in common, but we want to keep it interactive. We've discussed what challenges mediators might face, the challenges of parties, and of course the role of lawyers. That's how we concluded. So any one in audience, if you have any question, you can put it down in the chat box. In the meantime, I'll again go back to the questions that I have prepared. So just I'll take it as a common question to all the panelists. What kind of innovations do you see that are going to shape the future of effective mediation? And what are the best practices for handling complex or multi-party mediations? Annie, would you like to start?
Yes,
Should I?
yes, thank you.
Oh, please.
Okay.
Annie, it's your.
Annie, yeah.
Sorry, I have a problem with my microphone. Speaking about innovation or technological some skills, I can mention that looking ahead of technology will play an increasing role in shaping mediation. Of course, in nowadays it can be virtual mediation platforms that the rise of online platforms has made mediation more accessible, especially in international and remote disputes. And here in Armenia, we have virtual mediation also, and we can make sessions in virtual mediation in any application which can be reachable for parties, and it is a very good process and make it more accessible for parties. And of course, nowadays AI technology, AI-driven tools may be used, and using artificial intelligence can assist mediators in organizing data or analyzing of information. It could streamline the process. And of course, for a highly complex or multi-party mediations, clear framework and structure approach are essential. Some best practice I follow include phased mediation, then to break the process into stages to keep the discussion organized and focused on one issue at a time. And also, a neutral party can help manage dynamics and keep the process fair as well. Involving experts, facilitators who can assist the specific issues like finance or technology can also help to ensure that all parties have voice, have solving their problems. And as speakers and Beverly also mentioned, it is very important to educate, to translate many information about mediation, and online platforms will help great in this educational area to speak, to introduce more about mediation, about problems, about solving, about methods, to share skills, methods of mediators from different countries, and the online platforms can help very well in this area.
Thank you so much for highlighting specifically how technology is taking over and how do we handle online mediations and with options of breakout rooms, and how it can be as effective as it is as a physical mediation. Moving on to Amod now, what is your suggestion on the best practices and of course the technological or the procedural innovations?
Yeah, as put it across by Ani, in the ODR mediations, the platforms have come up, which are very robust platforms, where the documents are being uploaded by the parties, and mediator comes and takes stock of these things through the documents uploaded by the parties and resolves the matter. The other thing, what is happening in some of the European countries is that the co-mediators are being involved. apart from having one mediator, there are some co-mediators also joining the mediation team, and those people are the subject matter experts. So if there's a complex mediation happening, the mediator who may not be as much knowledgeable about the subject matter, so he gets a support by the co-mediator who understands the subject and helps resolving the issue. And then apart from co-mediation, the ODR thing is happening, and the experts, as you see in the arbitration, the experts are being called, who are the subject matter experts. If it is not the co-mediator who is around, the subject matter expert can come and uh, provide the inputs to the mediator about the complex issues. So the practice is coming up in various jurisdictions where the subject matter expert is being called, who can highlight the complexities of the dispute involved, if it is a complex issue between the parties. So these are some of the innovations taking place, and I think with these the things will improve slowly and slowly, and parties will also have their confidence in the system when the subject matter experts or co-mediators who are knowledgeable about the subject join the team and the process, so that the better resolution of dispute can take place.
Thank you so much. Thank you for highlighting about ODR and how do we handle complex mediations and the role a co-mediator who's a subject matter expert, what role a co-mediator can play. Moving on to Beverly now, your insights on the best practices and also about the innovations and technology, how technology is playing an active role.
Okay, thank you, Mahak. So quite a similar story here in Nigeria. So I belong to the Lagos Multi-Door Courthouse, in addition to others, and they actually didn't want to make any assumptions and made ODR training post-COVID compulsory for mediators, because the reality is we are in the digital era now. It's just easier for cross-border, and not just cross-border, even within a country as big as Nigeria, where you may have parties in completely different locations. It's a lot cheaper to have parties, meet online. So not just assisting cross-border, but certainly assisting national disputes. So the LMDC made it mandatory that mediators get the right training. Again, advocacy and training is a very important innovation. As old school as it might sound, it still has its place in helping to spread the message of mediation. I mean, as far as best practice goes, I can tell you that at least in where I live in Lagos State, the practice guidelines, which were passed sometime, I think in 2021, made mediation compulsory. So there's something that we do here whereby parties who proceed first to the High Court in the first instance are actually sent back for mediation. So mediation is actually now compulsory. I know that sounds very incongruous, but it is an innovation in legislation that actually does help spread the use of mediation. So that practice direction has certainly helped spread the using mediation as a tool. Definitely, I can tell you in the last 5 years, the uptake has been quite tremendous. When I look at my docket, when we even look at stats, let's look at statistics, let's look at data. I'm sure many mediation arbitral institutions will report that there's been a spike, particularly since the incorporation of tools like Zoom, Teams, etc. So for us, what we use and what seems to be working is the mandatory element. I think even in the UK, I did see something last year whereby they also passed a similar legislation. Don't quote me though, making mediation compulsory. So we do need that legislative backing to encourage mediation in a wider format. And then ODR is something I do preach. I certainly haven't done the physical mediation in about 3 years. All my mediations are online. I mean, there's a place for physical, don't get me wrong, there is a place, but for the time being, online seems to be doing justice to access to justice and also just making things a lot more easy for parties. So those are some of my takeaways and things I think I can share with the House in terms of best practices and the use of technology. And I do hope it will spread wider. Not all institutions are as adept with technology. I think some still, like for instance, we have a Court of Appeal mediation body. I'm not a member yet, but I do believe they are very face-to-face in person. So I think we need to see more mediation institutions embrace ODR so it can be more widespread. And so more mediators can also participate because the Court of Appeal, they practice more in our capital, and I'm not in the capital, I'm in Lagos. So those are just some of my takeaways. Thank you.
Thank you so much. And with this, I would like to thank all the panelists, of course, for giving, sharing their best practices, sharing how technology is playing a very innovative role. Now, I open the floor for questions from the audience. If any of you have any questions to be put up to the panelists, we are ready to take that up. I can see one question in the chat box by Sagar. In India, any firm or organization to work in India? So to start with, of course, it depends on what you want to pursue, where you want to go, what is your area of interest. There are so many factors that play an active role, but still, it depends. If you're specifically talking about mediation, Amon, do you have an answer to this?
Yes, there are various institutions. As there are arbitral institutions, there are mediation institutions as well. And there you can try your luck, and then these mediation institutions are eventually going to get recognized by the Mediation Council of India, which is yet going to see the light of the day. But that as soon as it gets notified, the mediation institutions will get recognized, and all those mediation institutions will have the empaneled mediators with them. And if you are interested in that, you can get empaneled as a council in those institutions, or you can get empaneled, provided you have adequate experience, you can get empaneled as mediator in those institutions. And slowly, when the cases start coming, you will have a chance of getting the cases as a mediator, if you have experience, or as a lawyer, as a counsel, not lawyer, as a counsel in the mediations. So that is what it is. But complete the education. I don't know your background, Sagar, but if you have still studying, then complete your education, then get in touch with one of these mediation institutions, and then the path is clear for you.
Thank you so much for taking this question up. Next question, I think, Beverly, it's addressed to you. Just like arbitration, is there any institution for mediation in Nigeria for one to be certified? I'm from Nigeria.
Thank you, Chineye, for that question. Actually, there are quite a few. So for me, I got empaneled at the Lagos Multi-Door Court, which incidentally was the first mediation. It's actually a court annexed institution. So what that means is it's an institution that practices ADR alongside the High Court. And they worked hand in hand with a body called CEDAR. I'm sure we've all heard of CEDAR in the UK. So they were the very first mediation institution. But right now, there's a lot more mediation-only institutions. So you have gosh, there's a whole bunch of them. ICMC, sorry. That's the Institute of Conciliators and Mediators. They're doing very well. You should Google them and look them up. There's IMT. There's quite a few. You can reach out to me and I can send you a list. But it's definitely a place where mediation is thriving. And when you get your qualifications from there, you can then get empaneled in places like the multi-door court, which is court annexed, and you have multi-door courts in different states in Nigeria, which is great. So I'm in the Lagos branch. You should find a branch, I suppose, in a state where you reside so you can practice institutional-led mediation. But don't forget, there's a place for private mediation. I must admit, I don't do private. It's something that I'm toying with. I'm very much institutionally driven, but yes, private mediation is also an option. There's a lot of private mediators doing very, very well. So yes, you have a lot of options in Nigeria, and I wish you all the best. Thank you.
Thank you so much for taking that question. Next, we have, of course, I think a lot of people who are attending want to build a career in mediation. They want to know what skills they should have. Next question is by Sujal. He's saying, as a recent law graduate, what all skills should I focus on to make a good career in dispute resolution? Thank you. I think I will open it for any of the panelists if you're willing to take this question up. What are the skills that a person should focus on to have a good career in dispute resolution?
Should I?
Yes.
Okay. Okay. All right. If you have known about the arbitration as an ADR process, there is no qualification laid down for an arbitrator. But as far as mediation is concerned, one is expected to undergo a 40-hour training. And there are various institutions which are giving 40-hour training, which is the basic training on the art and science of mediation. You know, mediation is a combination of art of mediating and science of how to successfully mediate. So this basic training of 40 hours is essential for anybody who can understand, who can make a career to begin with. But there's a caveat. Don't think that after having completed this 40-hour training, you will straight away become a mediator. You have to get mature in the field, and that will take time. So begin with the counsel work. If you get a chance, or if you can assist some of the counsel in a mediation process, start from there, learn the nuances of the trade, and understand how the mediation is conducted. Secondly, what you can do, there are institutions which are, after giving 40 hours training, make you sit in some of the co-mediation trainings, cases, matters. So there, if you go and sit as a co-mediator, you will understand what is the mediation all about, how it is being conducted, and how the mediator gets the work done through the councils and through the parties. So this is essential. So basically, to summarize the answer which you need, is the attend some of the 40-hour training, get the basics clear, and then get practical experience somewhere. This is all about mediation. But arbitration, if you want, again, there's no training for an arbitrator, but then you have to have some qualification of ADR, which various institutions are giving the 1-year certificate course, or is an elective also in some of the universities. That will give you the knowledge about the ADR processes. So, and the very important thing is make yourself abreast of the negotiation thing. What is negotiation? How to negotiate? What is communication? How to effectively communicate? So these are the basics which are required for one to come into this field and make a successful career. Hope I have answered.
Yes, you've answered it really well. You've covered as to what a person should look forward to if they want to pursue a career in dispute resolution. If there are any further questions, we are here to take it. But if there are no questions, I would just to add on, if somebody asked about trainings or okay, there's a question. Somebody wants to do a training. Mediation chambers also hosts trainings, organize trainings for mediations, 40-hour training. So and Resolve Academy and Mediation Chamber, they are doing a really good job organizing such discussions from time to time. If you're looking forward to have more resources, looking forward to have more editions of the panel discussions that we've done earlier, you can check out the website. Everything is put up there. If you're looking forward for any trainings, you can see it there. There's one more question, the last one that we'll take. I attended mediator training by CIAC, where a lot of focus was development of soft skill. I just want to know from Mehak, any book on how to frame questions? Okay, as a mediator, as she covered that particular topic. Oh, I think you got in touch with me. So yes, there are various, not specifically books, but there are various journals, there are various research papers that I refer to. What I'll do is I'll share the PDF with you, and specifically for negotiation, there's a really good book, Never Split the Difference, that I like. When we are talking about effective questioning, I do not refer to a book, but there are various handouts that I have. If you're talking about effective questioning, I can share that with you. I do have your number. I'm so sorry for not doing it till now. Tatwik has said there's a new edition of mediation training, will be in 2026. Follow.
Mehak, if I may, do you mind if I just
Yes.
say something to follow that question?
Yes, absolutely.
The person talked about there was a focus on soft skills. I will say one thing. In mediation, you have to have very good listening skills. You have to also pay attention to what is not being said, and that is how you unpack the obstacles that could be affecting your mediation. And that can also determine whether you go into caucus or not. I find that sometimes mediators are too quick to want to try and settle as a big forum immediately. No, that could be presumptuous. It's important to really pay attention to the signs, the body language, what they're saying, what they're not saying, and listen actively. Active listening will be your best weapon in a mediation, because that will then determine how you approach that mediation. And it's helped me quite a lot. I've found you go into caucus and they can just let it out, and that's because you were paying attention to what was said and also to what was not being said. So verbal, non-verbal cues, very, very important in mediation. You need that arsenal to be able to handle it. Yeah, so it's not always about questioning. I just wanted to let that person know that it's not always about how to frame a question. Sometimes if you're listening hard enough, you will know what to ask. So I just wanted to leave that there. Thank you.
Thank you so much. And there was another question about, reading material or any books. I think it's always good to share resources. So maybe if there's any specific book that you feel has helped you a lot, not only on effective questioning, but in general, or any article that is your favorite when we are talking about mediation, we can create a good pool of resources. So anyone, if you have any book that recommendation, any article recommendation, please feel free to give. You can type it out in the chat box, or you can unmute yourself.
If I may, one more time.
Yes.
I maybe you might have deciphered by now, but I'm very fascinated by psychology of people. And there's a book I'm reading at the moment. Well, actually, it's an audio book. And hang on a minute, because I've been listening to it every day. And it's by Robert Greene. I don't know if we've all heard of Robert Greene. He's done so many fascinating books. And it's just basically teaching me about human behavior, why we behave a certain way, cues, what to look out for. I find that paying attention to those things, in addition to my technical training as a mediator, has helped me quite a bit. So I'm just getting the name of the book for you now. It's called The Laws of Human Nature. The Laws of Human Nature by Robert Greene. Fantastic. Fantastic. It helps to read a lot, actually, widely, because it then informs your style. I think, how do we mediators find our style? I would say that I'm facilitative, evaluative, because I find that if I'm over facilitative, we don't get anywhere, depending on the nature of the mediation and the complexity and the party's personality. So I found that I've developed my own style. It's very important for mediators to feel comfortable not acting or acting a role. They need to connect with, themselves as people and apply that in any mediation they find themselves. So yes, Laws of Human Nature, fantastic on understanding human psychology. And yeah, that's my recommendation. Thank you.
Thank you so much. Robert Greene, of course, is an amazing author and has done so many amazing books. So I'm sure this one is going to be great. As I said, Never Split the Difference. I've liked that one. There's a book called High Conflict. I've liked that one as well. And apart from that, I will share links maybe to articles. I think, yes, Annie.
Yes, and can I add something? It's not about books, about learning, but about mindset, because we had the question about I am lawyer, what I need to do. First of all, you need to forget that you are a lawyer, financialist, or some specialist. You are the person what can help parties to solve their conflict, to solve their problems. So you must forget everything, and you must listening, you must be empathy, you must have patience, because parties are very emotional. They have many problems, many bad backgrounds. So you must be the trusted one. You must be the person who must help parties to solve their problems, to solve their conflict.
Thank you so much, Annie, for coming forward. And this, I think, is a great closing to the entire session. And thank you, everyone, for posting your questions. It was a really insightful session. Before closing it off, I would like to thank the panelists for taking out their time and for sharing their insights and experiences. And special thanks to Mediation Chambers, Resolve Academy, Tathwik, Melaine, and Alex, if she's here. Yeah, thank you so much, everyone. It was a great session.
Thank you.
Thank you so much.
Thank you so much.